All right, so we are very excited to welcome back Genevieve Gribble. Genevieve is an attorney and she's with Inter Vivos PLLC. She does many different types of estate planning and specializes in special needs estate planning. She also has a close connection to the special needs community. She has a brother with special needs and two nephews. She's presented for us before, and today we're really excited to welcome her back. The title of our webinar is Guardianship and Conservatorship, but we're going to be talking about many other transition topics. So we are excited to have you. And Genevieve, I will pass the presentation over to you. Thank you for being here.
You're welcome. It's a pleasure to be here. Let's see. Okay. I'm going to share my presentation. Please let me know if that is not visible. Okay, so the name of my presentation is Paper Hats Won't Keep Out the Rain. Now this is just, I had an experience a couple of years ago. I went to, it wasn't a presentation, it was just a place with a lot of different people who were interested in special needs. And one of the booths had a little craft they were doing, which was a paper hat. And this paper hat was so intriguing to the parents that they literally went past all sorts of different booths that had many interesting and valuable things to offer to get in line to get this paper hat for their child. And it was just a funny experience. I stood there and the line went past my booth and wrapped around the corner. It was just, all the parents were in line, and I stopped one man who was an older gentleman. I said, you know, what's up? Why are you in this line? He said, I got to get a paper hat for my granddaughter. And it just really struck me how, you know, this paper hat had just taken over everybody's imaginations to such an extent that other things that were more valuable were being pushed aside or ignored. And I think that can be how it is sometimes with our kids with special needs. And sometimes it's not actually that we just kind of lose sight of a long-term plan or something that's happening. I have, my twin sister has two boys with autism. She does all sorts of therapies with them. She spends hours every day with them, helping them, doing lots of stuff. But if at the end of the day, if she hasn't put in place documents, things that will help them when she is not there to help them, it's all of her work could be for nothing, okay? And it's just that idea of, you know, is what you're doing now, is that going to keep the rain off your child? Is that going to, when the hard times come, is that going to protect your child? So we're gonna go on. Let's see, my thing did not move my program along. Let me see, I'm screen sharing. Don't know why this won't move. Oh, okay, here it is. I don't know why that did that. Okay, awesome. Okay, so we say that, you know, every family needs a plan, and most families need a trust plan rather than just a simple will. And a proper plan should include the following. You should have a life plan, a transfer plan, and a family plan. So in your life plan, you need to know what's going to happen with you while you are living. If you are unable to make decisions, who's going to make those decisions for you? And that could be financially, that could be healthcare. Then a transfer plan. How are your assets going to be transferred to the next generation? Okay, what's the plan for that? And then the family plan. A lot of families have values and things that they want to pass to the next generation. How are you going to do that? Okay, now the timeline for a special needs child is a little bit different than other children. From birth to age 18, they're normally under the care of their parents. They're often not eligible for public assistance benefits because of the parent's income. So the government will look at that income parents are making and say, you just do not, you don't qualify, the child doesn't qualify. But once they turn 18, then their resources end and the child might qualify for public assistance because the government's going to look at your child's income alone. Now, this second piece is the one that kind of catches parents off guard sometimes. So parents' authority to make legal decisions for their child ends. This is irregardless of the extent of the disability. Whether your child may be completely helpless, they may depend on you for everything, but once they are 18, they have all of their legal rights that any adult has. And so you have to, in order to, now, and this is a funny area, okay? And we will talk quite a bit about this. I'll just give you an example. Well, no, I won't give you that example yet. We'll go on and we'll come to that. Okay, so there are 5 planning mistakes that we often see. We just call them our top 5 planning mistakes. The first one and the second one are similar. They're like the flip sides of a coin. So the first is disinheriting the child, and the second is not planning around benefits. So first of all, parents will say, okay, my child is receiving benefits. If they receive an inheritance, then that is going to disqualify them for receiving benefits. So I'm going to disinherit my child. Now, the thing that you have to think about on this is receiving benefits has a great deal of value, especially medical, but depending on your situation, there can be a great deal of value in that. But public benefits is a subsistence level, okay, of existence. That is not where most parents want their children to be. They don't want them just clinging on to a lifestyle. They want them to have a higher standard of living than is supplied if all you are receiving is government benefits for your support. Okay, so if you disinherit your child, there's no possibility that there's going to be this, some other thing from you that's going to support them. Then the second one, that flip side, is not planning around the benefits. So that's when, the child's receiving benefits, they receive an outright inheritance, and that disqualifies them from receiving benefits. So they lose those valuable benefits, and what they have is whatever, inheritance they've been left. And that, because it's been left to them outright, there could be some real issues with that. They could, this is the interesting thing, is that an average inheritance lasts 7 months to a year. And that is regardless of who receives it and how much it is. So if someone receives 7,000, or they receive 70,000, or they receive 700,000, within 7 months to a year, that will be gone. And I think that's because people get a large sum of money and they think it will never end, and they just blow it on all sorts of things, consumer things. And so that money doesn't end up having the value that it could. Now, with an individual with a disability, there may also be some vulnerabilities there to being taken advantage of by predators who are on the make for, people that they want to take advantage of. So the end result will probably be that your child loses their benefits, and then that inheritance gets wasted. Okay. Now, the third mistake is not putting things in writing. So this is very common. Oftentimes people sit down, they talk things out as a family, they talk with friends, they're saying this is something that they've thought about, and they've been very clear, when we pass away, we want to have, this person in charge of our minor child or our disabled child. They've been very clear, except they have not put anything in writing. If you do not have something in writing, you don't have anything to approach the court with, okay? Nothing that gives priority to any certain individual. And the court will entertain petitions from any interested individual on guardianship. So that could be anybody. It could be the last person you want to have in charge of your child. Okay, so not putting things in writing is a big problem. Okay, then relying on your other children to provide for the child with special needs. This one seems to make a lot of sense on the face of it, because a lot of times you'll have, if you have two kids, maybe, the older brother, let's say we have Jimmy and Johnny, and Jimmy has grown up always knowing that he needs to take care of his younger brother, Johnny, who has a disability. And that is something he has always done. And so as parents, you may not envision a time when Jimmy would not be willing to take care of Johnny, but things can happen. For one thing, when Jimmy gets married, his spouse may not be as interested in taking care of Johnny as Jimmy is. There are also, this is a way that people will disinherit. For example, the parents might disinherit Johnny and give Jimmy a double portion on the understanding that, Jimmy is going to use that second portion to take care of Johnny. The problem with that is that money is not, it is not Johnny's money, and it has no connection to him, and Jimmy is under no obligation to use that for Johnny. So Jimmy may change his mind. He may, use it for other things. Also, if Jimmy were to pass away, that money would not automatically go to Johnny. Could go to his spouse. It could go to his children. So that, that could be a real problem. And then waiting too long to obtain guardianship over the child. This one, a lot of times when the child first turns 18, that's a good moment to go over guardianship with them, to see what their needs are, see what sort of level of guardianship is needed, if a guardianship is needed. We had an experience a few years ago with a client who her daughter was 19, she was disabled, but she was part of she had a voc rehab program that she was in, and she would take the bus and go to her job a couple times a week. And one time she missed her stop and she didn't know what to do. So she just stayed on the bus until the end of the line. And then at the end of the line, the bus driver wasn't sure what to do. He could tell that she was having some difficulties and was confused. So he called the police, and the police came, and they, found out some information from her and talked with her. They called her mom, and her mom by this time was kind of concerned, wondering where her child was. And they told her, "We can tell you that she's safe. We can't tell you where she is." Why? Because she said, "Don't tell my mom where I am because she's going to be mad because I missed my stop." Okay, this was so scary for our client, because she's sitting there saying, I'm the one who's going to help my child, but her child is saying, "Oh, don't tell mom." That did get worked out, and we ended up being able to help with a guardianship. But there are things where you can have other experiences that are not as easily resolved as that one was, that can be very negative if that guardianship isn't in place. Something that I have seen happen a number of times is with young people who they start to feel, they don't want to be different than other people. They recognize that some of their friends are not in a guardianship, and they stop being willing to allow a guardianship, even though they may still be relying on mom and dad for a lot of help. And it can end up being a problem in the relationship. The parents could probably get a guardianship if they pushed the matter through the court, but what it might do to their personal relationship with their child, it could be very damaging. So it's best if in the moment in the first moment when that child is willing to do it and they really need the help, that be put in place then, instead of waiting until a moment when the child might really have desperate needs, but not be willing to do that. Okay, now a special needs trust plan, a complete one, would include the following. A special needs trust document of some type. It could be testamentary, which means that it comes into being after the parents have passed away, a third-party special needs trust, or a first-party special needs trust. Enable account, powers of attorney, healthcare directives or HIPAA authorizations, pour over wills, guardian designations, care plan, guardianship, or supported decision-making agreement. So this complete plan envisions parents and their child with a disability. So there are things that apply to both of them here. And we'll go into more detail about this. So, and then funding, we do like to use life insurance. It can be very beneficial. You can also use annuities, but you do have to watch the income limits of the beneficiary, because you can go over those pretty easily if you're not careful. Okay. So let's talk about benefits of a special needs trust. Okay, so back when we were talking about the problems of, like the planning mistakes, we said, one of them was to not plan around benefits. A special needs trust is where you are planning around benefits, and you will do that in, usually there's the three main ways where you'll do it, either through your own trust or will, which means testamentary, means it will be established once you pass away, or you will, set up a third-party special needs trust outright, or a first-party special needs trust outright. Okay, this protects, any one of those will protect eligibility for government benefits. It provides for a higher quality of life. Okay, so this is where we're saying you're not disinheriting your child, but you're not disqualifying them for government benefits. So they'll get government benefits, and then they'll get additional through the special needs trust that will raise that quality of life. And then a special needs trust will provide a framework for care and management of the assets that are within that trust. And this allows the parents, you as parents, to express your desires. It protects the assets from creditors and predators. This can be very, very important. And it extends the life of the assets. Depending on the type of trust you have, this can really extend the life of assets. And we will discuss this a little bit more when we get into the specialized kind of trusts. Okay, so the third-party special needs trust is one that most people have heard about, heard a little bit about. I think of it as the gold standard of special needs trust. It does not work in every instance, but it is something that definitely, if you have a child with special needs, you're going to want to look into this. Here are the details of it. So the trust assets are not available to the beneficiary. The trust assets are considered exempt for qualifying for Medicaid and SSI. The government cannot exercise estate recovery. This is very key. Okay, because this is a third-party special needs trust, it means that a third party other than the individual with the disability has established this trust and has funded this trust with assets. Okay, so nothing within that trust belongs to the individual with the disability. The individual with the disability can't revoke the trust. They don't have a power to compel a distribution of the assets. The money in there is not theirs, okay, although it can be used for their benefit. And because of that, when they pass away, the government cannot come after the assets that are left in that trust and recover the amounts that they have dispersed during the lifetime of the individual with the disability. Okay, so this can really extend the life of assets. Let's say that you put a family home into a third-party special needs trust. Your child with the disability may live in that home for the rest of their life. After you pass away, they may go on living there for 50 years and still be receiving government benefits. And when they pass away, that home, as long as it is still owned by that third-party special needs trust, the home will go on, continue on in that trust, and the residuary beneficiaries are not the government. Okay, so that could be your other children, it could be other relatives, it could be a charity, whoever you have designated. Okay, and so that, that protects the assets in there during the lifetime of your child and beyond that. Okay, now a first party special needs trust differs. Okay, there is still the assets are still considered exempt for qualifying for government benefits. But the thing is that the assets within there, they might be from the individual with the disability. So they might be something like, we had a couple years ago, we had a client who, she had a special needs trust that her parents had established for her, a third-party special needs trust. She had an aunt who put her as a beneficiary of a life insurance policy. She did not put the third-party special needs trust as the beneficiary. She put her niece, okay? So that money was received by her niece. That was her money, and she was going to disqualify for government benefits. So what she did instead was establish a first-party special needs trust, which was funded by that money that she'd received. Now that is really good because that can also, supply, and raise that standard of living. But the government, because that money actually has the connection with the individual with the disability, the government can exercise estate recovery. So once she passes away, whatever is left in that trust, the residuary beneficiary of the trust is the government. So the government can go in and they can pay themselves back. Now, a lot of times that paying back means that there is nothing left. Okay, so, but on the flip side, this is a good tool when you have certain situations. So anyway, let's continue on. Okay, now this one, oh dear. Okay, I don't know how to go back. Okay. I can't see the top of my slide here, is the thing. Sylvia, can you read the top? I know it's something like a revocable living trust, special needs provisions within a parental trust, something like that.
Yes, of course. This slide is details of special needs provisions within parental trust.
Okay, perfect. Okay, so what this one is, this is an interesting one. This is a third-party special needs trust, but it is only established, it's established because of provisions that are within the revocable trust of the parents. And so it's established once both parents have passed away. At that point, it comes into being and it has all of the hallmarks of the third-party special needs trust. Now, a downside of it is it's not available until the parents pass away. So this isn't a situation where somebody could say, if there was a doting aunt or uncle or grandparent in the picture, they couldn't say, I'm going to make this trust the beneficiary of my life insurance policy or my retirement plan, or put this in my will, or put this in my own in my own trust and say I want to have this money go into this trust. Okay, because that trust does not exist until the parents have passed away. So that is a limitation, or can be. The trust, but it does have all the other earmarks or whatever of a third-party special needs trust, where the trust assets aren't available, trusts are are considered exempt, so they don't disqualify, and the government can't exercise estate recovery, and the beneficiary can't revoke it, and the beneficiary cannot demand a disbursement. So it does have a great deal of power. It's just that it's not present until the parents pass away. Okay, so that can be a limitation. Now on this is something to consider, because a lot of times when a child is young, they don't necessarily need a third-party special needs trust. And also, but parents pretty much always need to have some sort of trust plan when they have, especially when they have a child with a disability. Okay. So what I generally recommend, I think of it this way, I generally recommend that parents make sure that their own plan is established, that they have a trust, will, powers of attorney. So their complete family trust plan is established, and then their trust has the special needs provisions within it, and that they do that first. Okay. And the reason behind this is that, especially if you have minor children or your child with a disability, it's the thing of making sure, okay, sorry, I'm kind of, yeah, but I always think of it this way. It's like when you're on a plane and they give you the little, service thing, the demonstration on safety and everything, and they say, look, if the oxygen goes low, a mask is going to drop down and you're going to put that mask on. Okay. If you're traveling with your child, you're still going to put your mask on first, and then you're going to put your child's mask on, because it is important that you are in a good place so that you can actually help your child. Okay. So this is the reasoning here. If you do not have documents in place that designate a guardian of your minor children or your disabled child, and you pass away, your child is going to be in a bad situation, or would probably be in a bad situation where they do not have a designated guardian, and there may be, arguments and problems and things like that. They could also receive money outright and disqualify for government benefits. Their money could be wasted. There's so many things that can go wrong if the parents don't have their own plan in place first. Okay, now details of an ABLE account. So with an ABLE account, assets are available to the beneficiary. The assets are considered exempt for qualifying for Medicaid and SSI. The beneficiary can contribute assets. Real property cannot be held in the account. Okay, and government estate recovery applies to the assets. So an ABLE account is an account. Okay, it's really great because it's something where you can put away, as an individual with a disability, you can put away up to $15,000 a year from all sources. You can put that away every year, and you can get up past $100,000 before you actually disqualify for receiving government benefits. This is a place where you could save money. Like, an individual with a disability may work, and they can save money without it being, without disqualifying for their benefits. So it can be really, really good. But there is that thing where, because the money has that direct connection to the individual with the disability, then the government can go back once that individual passes away, and they can pay themselves back out of any money that is remaining in there. So if you were to have, as a parent, if you had $10,000 that you wanted to put away for your child, for their benefit, you wouldn't put it into an ABLE account, because that the government's going to be able to, do estate recovery on those assets. Instead, you would put it into a special needs trust that's a third party one, so that it is protected, so that if your child doesn't end up using it, it will go to another place that's not the government, wherever you choose to go. Okay, now some details of powers of attorney and healthcare powers of attorney. Wow. Okay. So this is, a lot of times parents will think, okay, I don't necessarily want to take away my child's rights, so I don't know if I want to, maybe I should just do a power of attorney, not do guardianship or conservatorship. So it's important to understand that a power of attorney or a healthcare power of attorney, so a financial one or a healthcare one, it gives permission to parents to help with those financial and medical decisions, but it doesn't remove any rights from the individual with special needs. So it doesn't have protections per se. For example, you may have a power of attorney that allows you to, make financial decisions for your child, but because your child hasn't actually given up any rights, your child still retains the right to make all of their financial decisions. So they do have the right to make a contract. So they may go and make a contract, and that contract might be kind of unconscionable because maybe they really don't understand the value of money, but that would still be a binding contract because they are over 18. Okay. With a power of attorney, you can't reverse a financial decision that your child has made. Okay. So now details of last will and testament. Okay, so real property that passes under a will has to go through probate, okay, which means you pass away, if you and your spouse pass away and the house, your real property is owned in your names, you pass away, you go to court to actually pass that title, to change the title. So normally we would suggest that you not do that. Don't go through probate. Instead, put that into a trust, your own living trust. And then when you pass away, that trust does not pass away, it just goes on living. So there's no court action that has to be involved with that. It's important to remember that a probate action is a public action. Details of your will are available to the public. And this is where you get, people reading up on, okay, so what did this person's will say? Where did their money go? And then they go after, these predators will go after whoever inherited whatever there was to inherit. Then designation of guardian of minor or adult disabled child is also made in the will. So you can have, you make that designation there, and then that is a probate action once the parents pass away. And then you can designate a testamentary third-party special needs trust. So you could actually designate through your will, you can also do third-party special needs trust provisions within a will. It's not as seamless, but it is something that you can do. Okay, now let's dive into guardianship. Let me see what our time is. Wow, we don't have as much time as I wanted, but okay. So I've touched very briefly on some of these things, but so with your court supervised guardianship and conservatorship, you can end up with that if you haven't made your wishes clear. You can have family feuds. This is in particular with minor children. It can get very ugly if you have not designated a guardian and both spouses pass away. There's also what I've touched on abuse or misspending their inheritance, draining the estate, or a forced spend down to keep benefits. So these are things that we want to avoid through guardianship. Okay, how to avoid it. Okay, so you want to provide clear documents naming a guardian, and you want both spouses to be on the same page. So if you have a husband and wife, and one of them puts in the, in their will, I want to have, my sister and her husband be the guardians, and then the spouse does the opposite and has some other people, and then they both die at the same time. There could be a court fight about this. We don't want to have a fight. We want everything to be very, very clear, and we want it all to be in agreement. So there's no problems with that. Spell out why you're choosing this individual. Provide a care plan. Make sure that you plan to preserve benefits, and then provide the checks and balances. I'm kind of thinking I don't have my guardianship. I don't know if I have a guardianship. All the things I want on this. This is for adult guardianship. So I think there's one more. Whoops. Okay, that wasn't. Okay. So what I'm going to do is just go over guardianship for an adult child. Right. Well, I'll do this really quickly because this is the minor child. One thing I often am asked is, does the person who is the guardian have to be the trustee of the trust as well? No, they do not. You might have somebody who is very good with your child who is financially unsound. Obviously, you do not want to put somebody financially unsound in charge of finances, but you might not, you might know somebody who's very good financially, but they are not good with your child. You can divide those duties up. You can have a guardian who just, takes care of your child, and you can have the trustee who is responsible for the money. Okay. You can put the people together. You can have them work jointly, and have one who has, more power in making decisions. There are a variety of ways that you can divide these things up and arrange them, but it is really good to have backups on things. And then you can choose to name a trust protector if necessary. A trust protector is not the trustee. They're a person who is outside of that trust. They cannot be subordinate to the beneficiary. They can't be related. And so it's usually just a good family friend, somebody who is very trustworthy. And what they can do is they can go in and review decisions that are being made by the trustee. If they have any question about, if things are being done properly, they can go in and they can review that, and they can have the power to remove a trustee that is not doing their job properly. And that's part of the checks and balances. Okay, so let's go into guardianship of an adult child. So if you are considering doing that, if 6 months before your child turns 18, you can petition the court for guardianship. The things that you need, and there are a variety of ways to do this, and there are a variety of types of guardianships, because you can have a limited guardianship, and it can be limited in many, many different ways. And courts prefer limited guardianships because it's a very serious thing to take somebody's rights away. Okay. One of the things I like to tell parents is, when you look at your child, consider what you're doing for them right now. If you are doing practically everything for them, that guardianship is going to be, and they need you to do everything for them, you are probably in a position where you would need a full guardianship. Okay. If they just need help in certain areas, then you would limit the guardianship to those certain areas where they need your help. The thing about guardianship is it is open, and so you can revisit a guardianship. And then there are other things, like you can, as petitioners, the parents can actually represent themselves. So that is something to consider. I have had it's been kind of a mixed bag with my clients. Some of my clients have been very adept at filling out the paperwork. There's an online court assistance program. They have filled it out, they've done it, and it's been very straightforward. Now, there are other situations that are not straightforward. Okay, I'm thinking about situations where you may have, divorced parents that You know, with a child who needs a guardianship in a limited way, but it's very specific, that's probably not the situation where you want to be doing it yourself. Okay. And there can be other, you know, there can be other situations that just you probably don't want to represent yourself on. But there can be others that are very straightforward and you may feel comfortable doing it. The main thing to keep in mind is it really is up to the parents' like comfort level on how they're doing it. Like I said, I've had people who have astounded me because they have just gone and done it. I've had other people who have not felt comfortable to do it and they have delayed and delayed and delayed because they just, I don't know, they just weren't able to do it. Okay, so now your child is going to need to be represented. There are some very, um, some, there are some times when a child doesn't need to be represented by counsel, but they're very, it's very rare. We did for a while, for a couple of years, we actually had a law in place that allowed, um, if it was parents who were, you know, seeking the guardianship, and there were a couple of, you know, things, then that was allowed to go through with the child not being represented by counsel. But they've since, you know, kind of tied up some loopholes there and done some stuff to make it more difficult. Um, but the process would be, um, I don't know if you want to know the whole process, but basically you petition the court, there would be a hearing, um, and you would need to, parents need to have a doctor's letter that describes the child's disability. There needs to be, you know, it needs to mention, the petition needs to mention what sort of guardianship, you know, the level of guardianship, if it is a full one, if it is limited, what those limitations are. And then, yeah, it's just a court hearing, and then if it's contested, it goes to the trial court. So yeah, I think at this point, I think we should probably open it up for questions. Sylvia, you can let me know what you think. I think it would be nice if people were to tell me, let me know if they have some questions about things.
Yeah, definitely. I think that's a great idea. Feel free, if you would like to unmute your microphone and ask your question, you're welcome to do that. You can also use the chat feature. Genevieve, there's a comment and then some questions in the chat. You may have answered. The first one here is from Taylor, who had a question about families at the preschool and the daycare that she works for, wondering if it's too early for those parents to start thinking about these things.
It not, well, obviously guardianship is probably not, you know, not in the near future. They've got, you know, 14 years or so to go. But um, all the planning, it's something that should be thought about as soon as you know that your child has a disability. Once you know that your child has a disability, I feel very strongly that parents really need to be aware. They need to be thinking. It's like when I was telling you earlier about my sister and all of the care that she, you know, is giving her child. You have to think, what happens when mom and dad are gone? And this is something that, so right now I have, the youngest member of our family is my nephew. He is 7 months and he has achondroplasia. So he has dwarfism, and he's had a couple of surgeries already. Um, his parents are doing all sorts of things to take care of him. One of the really important things is making sure that their own estate plan is in order and has provisions for baby. That is something, it's like they are taking so much care of him. He requires a great deal of care and consideration, but all of that would mean nothing if they die without having a plan in place, because then who knows what would happen, you know? And so it's really like, as soon as you know your child has a disability, you should be thinking about these things. I know that it is not always top of mind, but it is something that should definitely be considered when you have a child with a disability.
I have a question.
Okay.
My husband and his ex-wife are divorced. My husband's here with me. And we have their special needs son. He has Down syndrome. He's 16 years old. They live in Idaho. We're here in Utah. And we're just wondering, so we don't need to do anything, you think, until 6 months before?
6 months before, probably. Are you aware of any on the ex-spouse's ideas on this matter?
No, they have joint custody, but we physically only have the kids or only have our son here about 20% of the time, in the summer and holidays and stuff like that. Our guess would be one of two things. He's kind of a handful, and so it'll either be great, go ahead and take him, or she'll fight us to the death, which has kind of been, it's been a very contentious 11 years so far. So we're just kind of wondering if 6 months is enough time. And if we do it, like I've heard if you do it before they're 18, then you have to do it again after they're 18. Is that true?
No.
Okay, awesome.
It just goes into effect
Once they're
on
18.
their 18th birthday.
Gotcha. Okay. What would you suggest? Would you suggest starting like now or in a year or?
I would think, to me, it's always good to start laying the groundwork,
Okay.
especially if you think that there might be issues, because you're going to need to discuss, is this going to be a joint, is this going to be a joint guardianship? Who's going to be on that guardianship? Is it going to be, Lori, are you going to be on it? You know what I mean? Like,
is there such thing as a joint guardianship? Like they have
yes.
joint custody? Okay, great.
Yes.
Awesome.
Yes. And oftentimes if you can have both ex-spouses on it, it can be a very good thing.
Okay.
Something else that I didn't mention is you can have another person on that. You can have one of your other children. That can make it a lot more seamless when you pass away, if you have someone who's already on that guardianship.
Right.
One of the things we had talked about, that I had brought up, was designating guardianship of your adult disabled child in your will. That is a probate action. But if you have, a child who, let's say take Jimmy and Johnny, if you actually put Jimmy on that guardianship, then as a co-guardian, then when you pass away, although the court needs to be notified of that, then there's, Johnny isn't left without a guardian, and there doesn't have to be a probate action petitioning all over again for guardianship.
So they could have the two parents plus their son who's 30 and married and has children. Like they could be a three-way.
And in a case like that, now it sounds like your son lives in Idaho. Is that right?
Yeah.
The guardianship action would take place where he lives.
Right.
Okay. So so I can't speak to what would happen in Idaho with, with that sort of action. They like you to, the individual with the disability needs to live in the county where that district court, where the action is brought. So.
Right. Yes, we would have to go there for sure. Okay.
And that is something that it's important. If you do something like that, it's really probably best that you not represent yourself.
Right. Yeah, we
will want to have a well-drafted order.
Right.
That says, because you've got co-guardians on there, you'll want to have an order that describes, what is the priority on making decisions. And that's not something that,
you specialize in, or is it,
Like, could we come to you for you to help us fill out the Idaho forms, or just kind of get your gut feel on some things, or?
you could ask me
Okay,
about that. This is my specialty area.
yeah,
But I don't practice Idaho law.
for sure, yeah.
So,
Yeah, I don't want to waste any more time. I'm sure
Yeah.
people have questions, but maybe we'll just call your firm. I guess we can get your contact information online.
yes.
We'll
In
book an
fact, I'll put my direct number here
That's great.
in the chat.
Okay,
And
perfect.
if you want to, anybody who wants to have a consultation with me, I offer a free consultation.
Okay,
If you've, attended this.
great.
So,
Awesome. Thank
Yeah.
you. Thank you so much. We really have appreciated. We just finished doing our trusts and will and all that kind of stuff, estate planning. So I think,
special-
good.
special trust as
yeah,
well?
we did all that stuff. So I feel good about it.
Wonderful.
Thank you so much.
You're welcome.
Thank you. I see a hand up in the video. Leah?
So I had a question. So our daughter is 17 and a half, and I can't even see myself where I am because of the presentation. So I hope you're getting me. But we just started, I just opened an OCAP account. So we're just starting this. I've been to several guardianship classes, but most of that of your presentation honestly goes over my head. I'm just trying to get the first steps of like what we need to do for this. We have actually a couple of good friends that are lawyers that are willing to at no charge to help us and our daughter.
Okay.
But can you tell me, like, I'm doing the OCAP and I'm getting the, the evaluations to put in there and so on.
Yeah, I mean, you can do that. It sounds like you are moving forward with this, right? And she's 17 and a half.
Yes.
So, and you're getting the evaluations. So you'll submit those. You'll file everything together. The court likes you to file all the documents together. So you'll take them to whichever district court you reside in. Where do you live?
We live in Harriman. Wouldn't it be Salt Lake County?
Yes, it will.
Yeah.
Okay. So yeah, you'll just take in your documents to the court and file those when you're done with them, when they're completed.
So other than that, I mean, shouldn't we start doing the other stuff, or it just seems a lot to do at the same time.
So, I mean, when you say the other stuff, do you mean your estate planning as in your other?
Yes. Yeah. Estate, living will, like,
Yes.
all of
You
that.
should probably get started on that, I would think.
Okay.
Yeah. But that is something like, seriously, just, you can set up a consultation and we can go over your particular situation. Because
Okay.
you may have things that are just different than other people have. And
Right.
so, yeah.
Okay. Thank you.
You're welcome.
Great. We'll take some questions from the chat. There's about 5 questions in here. The first
Okay.
is from Sherry. My husband and I have full guardianship of our 2 adult children with special needs in California. We just moved to Utah 7 weeks ago. Do we need to start over here in Utah?
No, but you will need to get that guardianship registered. I don't know if registered is the right word, but you'll want to talk to the court, the probate court. Where do you live, Sherry?
Mute. Okay. I think I unmuted myself now.
You did. Yeah.
Okay. We live in Springville.
You live in Springville. Okay. So you're going to be
Yes.
in the 4th District Court. Yeah, you can approach the court and ask them to recognize the guardianship.
Okay.
Okay. And then they will let you know.
All right.
This is
that's
something,
really good news.
Yeah, but I don't believe you would need to redo the entire thing.
Okay.
Generally, states will recognize other states' guardianship.
Okay.
There may
Oh,
be
that's
some
perfect.
hoops to jump through. So, but this is something, if you would like to, you can meet with me and we can go into a little more depth on that.
Okay, that would be great. Thank you so much for your presentation.
Oh, you're welcome.
Okay, our next question in the chat is from Carrie. What are the pros and cons to getting partial guardianship? I have a friend who said our kids can't get married if you have full guardianship. Can you change the type of guardianship you have? And if so, how difficult is that?
So here is something to keep in mind with a full guardianship versus a limited guardianship. I have had parents who were very concerned about getting a full guardianship, even though their child really needed it, because they felt like they would be, that was being one of my clients termed it like a dictator. So if your child needs a full guardianship, then that's what you should get. If they only need a limited one, you just get a limited one, limited to where they have those needs. But it's really up to you. Your child could get married with a full guardianship with your permission. Okay. If you're not willing to give your permission, then obviously that would be a problem. But it's basically, you are in the position of being a parent of a minor child once again when you have a full guardianship. Okay, so those rights do not belong to your child, they belong to you. Okay, but it depends on what kind of person you are. A lot of parents that I know are not dictators. They're not overbearing. They really are like, they really want their children to do things for themselves, and they really celebrate, their children being able to be independent. But when they're not able to be independent, having a guardianship in place gives parents tools that are very, very helpful. I'll give you an example. My brother is an individual with autism. My parents do not have a guardianship over him. He has always had a great deal of independence, but he's always been very vulnerable to people we call friends. They're just people who take advantage of him, and he always says, "Oh, they said they were my friends," And we had a thing a few years ago where he was on the rugby team. He was an emeritus member because he had been injured, and he's never played rugby since his injury. And he was approached by some rugby players and asked to co-sign the gym membership for the whole team. He was never going to use this, okay? But they were his friends, and he really loves these guys, and they really are. I mean, they really love him too. But they asked him to co-sign this. He co-signed it, and then they did not make the payments. And so my parents ended up paying almost $4,000 to, end that contract, to fulfill it. Now, if my parents had had a guardianship over my brother, that would have been null and void. They wouldn't have had to pay a dime, or he wouldn't have had to pay a dime. Okay, because he would not have had the legal capacity to make a contract. Okay, so if your child has problems, I think maybe I'm bird walked here, but if your child has any issues financially, it is really important to at least have a guardianship that takes care of that aspect, that says financially they cannot make contracts. Okay. And then I'm seeing, what are the pros and cons, partial guardianship? We wouldn't say partial, but we would say limited. I think there's a lot of pros to getting a partial guardianship, and then I use that term, a limited guardianship. Because if your child doesn't need a full guardianship, the court is going to be very concerned that you're requesting a full guardianship. So in any way that it can be limited, that will be positive. So you can change your guardianship. You can, you can adjust it. that is going through the court again, but like I said before, a guardianship is always an open action. And so as long as that individual with the disability is alive, then that continues on and can be adjusted. So it could be changed to say, okay, we're not gonna, we no longer need financial, power over this individual, or, maybe medical has ceased to be a problem. So, and then let's see, having supported the child, let's see.
Genevieve, we have a question from Joe. How quickly can we get guardianship accomplished right now? And what if we do not get it done by 18? Child's turning 18 in a little over 1 month.
So a month probably gives you enough time, depending on the court. If you're in 3rd District, which is Salt Lake County, that's Judge Faust. As long as the guardianship is uncontested, you could file everything. You could probably get it in place by your child's birthday. But it does depend on the hearing dates, like what is open. Salt Lake County is usually pretty open, actually. Like, they're busy, but they have a very open calendar, where like Utah County meets top, 3 times a month. And it's always on a Monday at 2 p.m.
I would think we're probably going to go for full with our child, with our, well, soon to be adult child. And then if we were to bring you into it to help with that, would your schedule allow for that?
Yes, that would work.
Okay.
So,
Cool. Thank you.
you're welcome.
I
Okay.
think the last question in there, I know we're a little over time, and thank you so much for staying.
You're welcome.
We had a question about, in general, and I'm sure it changes, but how much are court fees to accomplish these things?
So court fees are anywhere from $35 to $375. Those are court fees. The nice thing about Utah is if you have even just one parent on a guardianship, then that action only costs $35 in court fees. If you have, if there is no parent on the guardianship, then it is $375 for the filing fee. So parents, in Utah, we support parents. That's what I think. So.
Thank you so much. I think we addressed all of the questions that were in the chat. Thank you. And folks, I did put at the bottom of the chat, in case you didn't catch it earlier, I re-put in Genevieve's email and her direct phone number in case you wanted to reach out and speak to her individually after the presentation.
Okay, well, thank you.
Yeah, thank you so much. We appreciate your time. Thank you for staying late to answer all of our questions. We are so happy to have you back, and thank you all of the parents that joined us today. We hope that this was very helpful. And again, Genevieve's contact information is in the chat box, and I'll leave that open for just a minute here, so that way you can make sure that you get that information. All right. Well, everyone have a great evening, and we will see you at the next one. Take care. Thank you.
Bye.